Good day, future lawyers. This video is a comprehensive presentation about summons under Rule 14 of the 2019 amendments to the 1997 Rules of Civil Procedure. Section 1. Clerk to issue summons. Unless the complaint is on its face dismissible under Section 1, Rule 9, the court shall within 5 calendar days from receipt of the initiatory pleading and proof of payment of the requisite legal fees direct the clerk of court to issue the corresponding summons to the defendants. On the other hand, Section 1 of Rule 9 provides Rule 9 Effect of Failure to Plead. Section 1 Defenses and Objections Not Pleaded. Defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment or by statute of limitations, the court shall dismiss the claim. Section 2 of Rule 14. Contents. The summons shall be directed to the defendant, signed by the clerk of court under seal, and contain A. The name of the court and the names of the parties to the action. B. Which is a new provision. When authorized by the court upon ex parte motion, an authorization for the plaintiff to serve the summons to the defendant. C. A direction that the defendant answer within the time fixed by these rules. And D. A notice that unless the defendant so answers, plaintiff will take judgment by default and may be granted the relief applied for. A copy of the complaint and order for appointment of guardian ad litem, if any, shall be attached to the original and each copy of the summons. Section 3. By whom served. The summons may be served by the sheriff, his or her deputy, or other proper court officer, and, in case of failure of service of summons by them, the court may authorize the plaintiff to serve the summons together with the sheriff. In cases where the summons is to be served outside the judicial region of the court where the case is pending, the plaintiff shall be authorized to cause the service of summons. If the plaintiff is a juridical entity, it shall notify the court in writing and name its authorized representative therein, attaching a board resolution or secretary's certificate thereto, as the case may be, stating that such representative is duly authorized to serve the summons on behalf of the plaintiff. If the plaintiff misrepresents that the defendant was served summons and it is later proved that no summons was served, the case shall be dismissed with prejudice, the proceedings shall be nullified, and the plaintiff shall be meted appropriate sanctions. If summons is returned without being served on any or all the defendants, the court shall order the plaintiff to cause the service of summons by other means available under the rules. Failure to comply with the order shall cause the dismissal of the initiatory pleading without prejudice. The notice shall be in writing and accompanied by a board resolution or secretary's certificate, and the person to serve the summons must be duly authorized to do so. Section 4 is a new provision. Section 4, validity of summons and issuance of alias summons. Summons shall remain valid until duly served unless it is recalled by the court. In case of loss or destruction of summons, the court may, upon motion, issue an alias summons. There is failure of service after unsuccessful attempts to personally serve the summons on the defendant in his or her address indicated in the complaint. Substituted service should be in the manner provided under Section 6 of this rule. Section 5. Service in person on defendant. Whenever practicable, the summons shall be served by handing a copy thereof to the defendant in person and informing the defendant that he or she is being served, or if he or she refuses to receive and sign for it, by leaving the summons within the view and in the presence of the defendant. Section 6. Substituted service of summons. If, for justifiable causes, the defendant cannot be served personally after at least 3 attempts on 2 different dates, service may be effected a. By leaving copies of the summons at the defendant's residence to a person at least 18 years of age and of sufficient discretion residing therein. B. By leaving copies of the summons at the defendant's office or regular place of business with some competent person in charge thereof. A competent person includes but is not limited to one who customarily receives correspondence for the defendants. Letter C. By leaving copies of the summons if refused entry upon making his or her authority and purpose known with any of the officers of the Homeowners Association or Condominium Corporation or its chief security officer in charge of the community or the building where the defendant may be found. And D. By sending an electronic mail to the defendant's electronic mail address if allowed by the court. Section 7. Service upon entity without juridical personality. When persons associated in an entity without juridical personality are sued under the name by which they are generally or commonly known, service may be effected upon all the defendants by serving upon any one of them or upon the person in charge of the office or place of business maintained in such name, but such service shall not bind individually any person whose connection with the entity has, upon due notice, been severed before the action was filed. Service upon prisoners. When the defendant is a prisoner confined in a jail or institution, service shall be effected upon him or her by the officer having the management of such jail or institution, who is deemed as a special sheriff for said purpose. The jail warden shall file a return within 5 calendar days from service of summons to the defendant. Section 9. Service consistent with international conventions. Service may be made through methods which are consistent with established international conventions to which the Philippines Section 10. Service upon minors and incompetents. When defendant is a minor, insane, or otherwise an incompetent person, service of summons shall be made upon him or her personally and on his or her legal guardian if he or she has one, or if none, upon his or her guardian ad litem, whose appointment shall be applied for by the plaintiff. In the case of a minor, service shall be made on his or her parent or guardian. Thank you for watching. Part 1 has been concluded for now, but we shall continue with part 2 coming up soon. Subscribe. Thank you.